By the way, it reminds me of Shrek. Not Shrek. Toy Story. There's a snake in my boot. Clearances, please.
Thank you very much, Your Honor. Attorney Robert Ringstrom, Assistant Prosecutor from the second time.
Thank you, Your Honor. Patrick Terry on behalf of Hunter Eargood, who is present.
Thank you very much. All right. Also here before the court this morning is Miss Laura Odell. She's an agent with the Michigan Department of Corrections, and we're here today for sentencing. She's covering for Mr. Blazak to prepare today's pre-sentence investigation report. And not intending to call her out, but Linda suggested maybe I might need more coffee earlier, and I'm now going to say, don't want anybody on any record going, well, we need more coffee. All right, so we're here today for sentencing on this case. I'm going to note that I had some issues here. With the scoring of the guidelines, because I want to make sure that they're correct.
I did as well, Your Honor.
Well, and mine go both ways though. On, off, oops, hold on. Oh, wrong way. Offense variable number 2 was scored for 1 point for possessing any other potentially lethal weapon. I think that was for the knuckles,
Correct, Your Honor.
but the knuckles had something on them. And it was a knife.
It was a pocket knife, Your Honor, yeah, with brass knuckles as the handle.
Okay, that's
As
what I
the
was looking.
guard.
That's what I was looking for, is to know a little bit more about it.
Yeah.
All right. Was it a folding knife? though?
Yes.
So the question here is whether or not that is a quote knife or other cutting weapon. You'll note that I reduced the word stabbing because I don't think it was necessarily a stabbing dagger, pointed, double-edged kind of thing. But it was a, thank you, Linda, you are awesome, and I'm sure everyone appreciates that for me. Wow, that's hot. Okay, all right, Mr. Rickson.
I do believe it counts as a knife, Your Honor, and
Yeah.
therefore I do think that it should be scored as a 5 point.
All right, Mr. Sherry,
I don't disagree, Your Honor.
thank you. Offense variable number 2 will be adjusted from 1 point up to 5 points. Now, next question here is offense variable number 12. Currently, it is scored at 5 points. 5 points is scored when there is one contemporaneous felonious criminal act involved against a person. I don't think we have any other felonious acts against a person. Next question. Were there 2 contemporaneous felonious criminal acts involving crimes against a person, or 3, and this is the one I'm raising, 3 or more contemporaneous felonious criminal acts involving other crimes? Well, we had the CCW, we had the felon in possession of ammunition, we had possession of a stolen vehicle that would be receiving and concealing. Make sure you talk to, we're just raising issues. I haven't made any changes in the scoring yet. I'm just raising them for consideration. Now, let me go back and take a look here.
Mhm.
I know it's mentioned here in a second. Let me find out. I thought there was some reference about Leroy. Not Leroy the person, but Leroy the community. Maybe I'm thinking of a different.
It's towards the bottom of page 3. It's a corpus delicti confession,
Yeah, and so I'm just raising it, so I'm covering the issue because I don't want anybody to miss it. There's a confession of sorts about there being other prior criminal activity. And when you look at, just saying, and by the way, maybe sometimes this is just all academic, and I like the academic arguments. When we looked at offense variable number 12, you can't have a conviction on a statement alone. Corpus delicti, you need the object. Is it part of any felonious criminal activity? Because I don't know if we couldn't be convicted of it. But when somebody admits the felonious activity, I don't think I can score it. But for whatever reason, I just like to talk about these things because I really hope it encourages everybody to make sure they're doing a really thorough job on looking at these things. Because, by the way, whether or not I consider it, and there's the other thing, I think I could consider it, which is, by the way, the lesson I was trying to mention earlier. I think I could consider it for reasonable grounds, but anyways, I don't think I can score anything more. Right now, it's 1 contemporaneous is the 3. I don't think it's 3. Do you have any argument at all you want to make, Mr. Ringstrom?
There was some ammunition that was found, but I don't see it in the report, so we're not gonna.
Yeah, well, the CCW was 1,
Right,
and the felon in possession of firearm is 2, but it's not 3. Potentially, I think there could be a 3rd because there's an allegation of delivery. Also, therefore, I don't think that it would score under OB 13 either. So I just like these conversations because I think we all learn something from them. And plus, I like to hear myself talk. It's a lovely voice. Anything else, Mr. Ringstrom? Any other amendments, corrections, objections to content or scoring?
the only other thing would have been OB 19, Your Honor.
Yeah, and this one I thought about as well, and I circled it. Now, this one, I think, here it's where he lied by giving a false name. He said that his first name was Joe. His name is not Joe. Now, there's another thing he says at the bottom of page 2, quote, "I'm going to jail, dude. I got that dude stuff in my pocket." It wasn't really a lie because apparently he said he was delivering it. I don't know. So that's not there. And so I'm just thinking about these things. Any other further argument? It was a lie. I don't know if it was enough because it really wasn't going to obstruct justice because they had him there. So I was thinking about it being an offense 19. Any argument for or against?
Your Honor, I believe that it could wind up, I think it could really go either way as far as the court's concerned.
How about you, Mr. Chair?
Well, Your Honor, I think that under OB 19, I think the obstruction of justice didn't actually occur because the deputy that was there recognized him and knew who he was. So he gave a name, but they knew who he was, so it didn't really impede the investigation.
It's really the word attempt. Because an attempt could be. But I liken it to this. My wife comes in and says, "Did you take a lick of the frosting off of the cake?" And then I say, "No." Then I have some on my lip. So I did reach out to the Department of Corrections because I wanted them to look at it. Because I think these things are always worth talking about, but I'm going to leave the scoring. All right, anything else, Mr.?
Nothing else from prosecution.
How about you, Mr. Cherry?
Justice to the scoring, Your Honor, I believe PRV 5 should be scored at 2 points. Conviction 5 of 5 occurred before the incident in 4 of, or I'm sorry, the conviction on 5 of 5 occurred after the incident in 4 of 5. Therefore, it should not be scored.
Yeah, Mr. Rickstrom?
I will leave that up to the court.
Yeah, I'm gonna say that's correct. All right. So that was PRV 5 will go down from 2 to, I'm sorry, 5 to 2?
Correct.
Thank you. Now, I suspect
That will have an impact.
That brings us, it doesn't have an impact on the PRVs. I don't know about the OVs.
well, hold on. So we're gonna go over our scoring.
27
So
on
we
the
got
PRVs.
27 PRVs, that keeps us at level D.
Correct.
And then we have the OVs and we added 4 points. And that's gonna make us a total OV point level of, I'm sorry, number at 10, increasing the OV level from 1 to 2. And that's going to change the guideline range from, hold on.
Did we change OV 12?
No, we just did not change. We did not change it. It could have gone up to 10 is what I was.
Understood.
All right, so we are D, where it's a 5 to 23. All right, anything else in there, Mr. Cherry?
No, Your Honor.
All right, thank you. Now, there's also another method to the madness lately, at least today. I don't do it all the time, but I do it when I think it's appropriate. I'm really looking at some of these PRV and OV scorings, and I just want people to make sure they are doing the same. That's really the reasons here today. All right, so now allocution. I'm going to start off with Mr. Ringstrom, just for the heck of it today. Go ahead, sir.
Your Honor, we believe the recommendation is fair and sound. Realistically, although the guidelines changed, the recommendation was still incarceration with 24 months probation at this point in time. We would just ask the court to follow that recommendation and how it sees fit as far as incarceration.
All right, thank you. Mr. Cherry.
Maybe I misunderstood the court's question earlier. I didn't have any other corrections to the scoring. I did have corrections to the body of the.
Go for it.
First, the attorney is not Mr. Champion.
Oh, my gosh. You know what? I normally look at that. Sure enough, I did.
And I only know that because I received this yesterday because his office had received it.
Copy that. That's changed. Thank you. Next one.
Prior record misdemeanor should be 1, not 2. On that same page.
On which one? Prior.
CFJ 145, prior record, and throughout misdemeanor should reflect
Yep.
1, not 2.
Yeah, because the one was actually after. All right,
Correct.
keep going.
On CFJ 145, page 2, under the jail credit, under action, it says violation arrest. That was actually a fail to appear in court that he was arrested on the bench warrant for. I don't know if that differentiates what we put in that box. I want to make sure that the court doesn't know that it was a testing violation or something like that.
We'll just leave it as is, and I'll accept your statement today as part of the allocution. And
Thank you,
so
Your Honor.
apply it. Thank you.
On CFJ 284, page 7, under employment, Mr. Eargood has just recently become employed at Hutchinson's. It started on September 10th.
Okay.
Making $16.25 an hour doing molding work.
Okay.
which would then also update CFJ 101, page 1.
All right,
And that's it.
thank you very much. Now, allocation, Mr. Chair.
Thank you, Your Honor. Two
Wait,
big,
hold on, Mr. Riggs, should be all like, sorry, do you, there was a leading question. Do you feel like you need any further comment?
No.
Thank you. Now we're back to you, Mr. Chair.
thank you, Your Honor. Two things that I want to address here. One, the jail credit and what they represent. So the first violation arrest there was a mistest. I just wanted to remind the court that that was a mistest back in the beginning of the testing, and that's when he was dealing with Roscommon County. And so that was the reason for that mistest. And then in July, when I replaced Mr. Champion, there was a period of time there where Mr. Eargood wasn't certain who his attorney was, and that was why he failed to appear in court. I appeared very recently after he was arrested on that bond violation. He was released by the court back on bond because of the situation. He did fail to appear, but there was a confusion regarding who his attorney was and when he needed to be in court, and so I wanted to address that. The second thing I wanted to address is Mr. Eargood has been working on getting into outpatient treatment, and he's been working with Medicaid or Medicare and getting signed up because Catholic Human Services requires him to have Medicare in place, because unlike when it's an order by probation, the court doesn't pay for it prior to. And so he's been trying to get his Medicare set up so that he can get outpatient treatment. That's his desire. I think, Your Honor, this is a young man that we're catching relatively early on compared to a lot of the other cases that I have in front of Your Honor, where we could maybe still have an impact on the direction that he goes from here. And I think that by seeking outpatient treatment, he's making a good decision. He's also stopped associating with those individuals, which led him to participate in these types of things. Most importantly, no longer in a relationship with Miss Molly White, which I think is a very positive choice for him. And so I wanted to fill those blanks in that are not contained within the PSI report. Thank you.
Thank you. Mr. Eargood, you have the right to make a statement if you choose to do so today. Now would be the time. Is there anything you wish to say, sir?
No, Your Honor, I think Mr. Cherry covered it.
All right. Just to be, I know I joke occasionally about hearing my own voice talk, but the appellate courts make me have to say a lot of things. So that way I can explain the sentencing and make some findings today, which is perfectly appropriate. Number one, you're 23 years old. All right. I know that's young, but it's time to stop being stupid. All right. Sorry, I know stupid's a bad word. It's been a bad word forever, but nowadays I can't tell which words are bad or good. So I'm just,
It's accurate, Your Honor.
but I'm just hoping to talk to you and allow you to understand. Now, when I look at CFJ 145, page 1, right at that bottom, personal history, that's a lot of drug stuff going on down there. All right. And it all started at a very, very young age. And that's concerning to me because it means you started out apparently with really bad supervision or whatever. I don't know what it is, but
I moved out of my house very young, Your Honor.
okay, well,
I was not supervised for most of my younger days.
well, most men, no matter their age, go unsupervised. All right, so then when I look here, and I gotta call this out, it's really hard. Sometimes as a judge, not everybody appreciates it. But be a judge, there's things here I've got to say, and I'm not trying to pick on anybody, but I'm really trying to highlight the significant benefit here in this case. Now, you had the possession of meth dismissed. Right? No, I'm sorry. You had the possession with intent to deliver dismissed. You had the carrying a concealed weapon dismissed. But there were other things that you could have been charged with. I don't know why you weren't. That's the prosecutor's choice, but I'm just making note of them that they're there. Let me tell you. Well, it's not a criminal conviction here, but you're riding around with a known felon and drug user. There are very few names more common lately in this courtroom than that name. Partially burned marijuana, no, that's illegal transport. I don't know why, by the way, nobody took in and got a subpoena for a blood draw. Because that could have been driving under the influence of marijuana or whatever,
If I may, Your Honor, he wasn't driving, Molly was.
or what, I'm sorry, but still. All right, but, all right, thank you very much for letting me know. I missed that somewhere in here. The ammunition, because you had a prior felony, right?
Yeah.
Yep, so that's illegal. You know, the meth case was pretty simple. You had a meth pipe in your boots.
Yeah.
By the way, it reminds me of Shrek, not Shrek, Toy Story. There's a snake in my boot. Sorry, I had to do that. I used to do it for my kids. All right, but anyways, you had meth in the boot, the weapon, possession with intent to deliver. You made statements here that give me concern. While I don't make a finding that you're guilty of them, I'm going to take them and say that there's definitely some preponderance of the evidence that, one, you were using methamphetamines at least 2 days prior to this. 2, you have been involved in some other delivery. So you're basically a drug dealer. Now, I know here it says you take this position. Yeah, I had some of it, but it wasn't mine. It doesn't matter.
Shouldn't have to be.
No, this coffee cup is not mine, but it's in my possession. So you had a statement here. It says, quote, the defendant stated he is not a drug dealer, end quote. Nope, that is not true. I do not accept that it is true. You are a drug dealer. You have been dealing drugs. It says right here in the paragraph above it, quote, he said they then sold the methamphetamine to an individual in Leroy and that they lost $200 in the transaction, end quote. That is by definition a drug dealer. So another thing here is, well, you knew right away to ask to speak with a certain group, agency. That means you had it in your head to know to ask to speak with that particular law enforcement agency. That means you got some experience here. So you're 23, a lot of drug history, drug dealing, drug possession, and you did lie to the officer about your name. When I look in the past here, your criminal history, your first criminal conviction was back in 2021. You violated probation in that case. And here's this sticks out to me. I don't want Mr. Cherry to tell you the answer. How many days did you make it before you violated probation?
Was this that very first instant? I don't recall. I'm pretty sure it was pretty quick after.
16 days, 2 weeks. That's not good. Then when you were discharged from probation, you made it about 1 year. That was only a case and then it was dismissed, so I'll disregard that. Then you pick up this case and got an arrest date on March 31st. Then while on bond, in exactly 14 days, picked up another charge.
This is the last common one.
Yeah.
Yeah.
So
I was more, Your Honor, not being where I was supposed to be, being with someone, you know, I mean, I was supposed to be with,
I got it.
you know,
Yeah.
kind of all caught up in one time, you know.
My wife's fault for leaving the cake on the counter with the cream cheese frosting, which is my favorite. She shouldn't have done it. She should have known I was gonna put my finger right through it. I do it every time. 32 years of marriage, I've always done it. All right, so here's what we're going to do today. Now, this is now a straddle cell of 5 to 23. That means the court does not need to make statements of reasonable grounds. However, pursuant to People versus Posey and the case law that came before and after it, the court is still required to state the proportionality and reasonableness of its sentence. This is not a case of first impression. This is not the first time the defendant's had any involvement with the drug world. It's not the first time that we've had possession, use. It's not the first time he's had even been involved in a delivery. And he's violated probation and bond already in just a couple cases he's had. He's already violated supervision. Yes, I know the most recent ones are, we've already talked about those, but you can't, you're already starting off in a very, very bad position. And again, proportionality, this case wasn't just a possession. This was a possession with intent to deliver while carrying a concealed weapon and possessing fire or ammunition and so forth. So the court places the defendant upon a period of probation for 24 months. The court adopts the terms or conditions for probation that are listed on CFJ 145 pages 2 and 3. I find that those are well suited for rehabilitative purposes, specifically the terms or conditions involving treatment, testing, not to possess or use alcoholic beverages or other intoxicants and controlled substances. This court, looking at the defendant's prior use history here, gives the court a great deal of concern for all their substance use disorder on a variety of substances. The court assesses a $68 state minimum fee, a $130 crime victims' right fund fee, a $300 court cost, a $500 fine, a $300 attorney fee, supervision fees of $30 a month or $60 a month if there's any electronic monitoring. Now, as to whether or not, as to a period of confinement, I definitely feel that a period of confinement is necessary here. I know I'm not sentencing him for a possession with intent to deliver, but the facts would support it. And the fact is that he's got a plea that reduced the guidelines. And so all those factors are already taken into consideration. So Miss Odell, I think the defendant would be eligible for boot camp. Correct? He hasn't had it in the past. Okay.
Yes.
All right. Thank you. Okay. So pay attention. I think Mr. Cherry's already warned you because I heard you make a noise, and that's okay. Now, I'm not going, this is not open for discussion, right? I'm not negotiating with you. I'm just going to explain my reasoning, okay? I'm more than likely to give, I'm sitting here on a fence. Do I put you into county jail for a year and then give you probation? Which, and when I say, well, should I, that's not a question, that's just what's going on in my head. And then if Miss Odell can get you into treatment early, that'd be great. And of course, you get 2 months of good conduct time. You'd be out after 10 months minus whatever time you've already served. Or I can change the program. Because you would be eligible for boot camp, if I give you a prison term, say 15 to 120 months, and you join the boot camp program, you're going to get out faster than if I put you in the county jail. Now, in our county jail, we do have a social worker through Catholic Human Services, Ms. Platts, and Wexford and Missaukee County Boards of Commissions have just approved use of opiate funding to hire another counselor to come over here. And that could be helpful. But I have to try to decide what is the best way to help you stop making stupid decisions. Now, you mentioned earlier that you weren't supervised much as a kid growing up. And you've mentioned your weakness of being around people when you're around people who are also using and so forth. So, hold on. It's okay. It's not for discussion.
I'm sorry.
I'm just explaining it. So before I give you the sentence, you have an idea of why the sentence is being given and what I hope for you to happen. Now, and the next comment is, it's not intended to be politically sensitive or insulting to any party or blah, 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 or other branch of the government. But it's unfortunate that we don't have a rehab inpatient facility here in Missaukee County or in Wexford County. We have Catholic Human Services and Addiction Treatment Services up in Traverse City. And there really isn't much money to help us send people to those places. And I want you to have something inpatient where you have got a structure, right? I don't think you have a GED or diploma. So there's already a step of lack of structure. I know you just got a job, but so that's what I'm thinking. And so I don't know what I'm going to do. I'm just going to say, hold on.
Sorry.
It's okay, sir. You're doing it politely. What would you like to say?
I just really like if to not go towards, you know, what I mean, like if I could stay out, you know, and
That's not gonna happen.
so.
So I'm trying to decide
You're gonna
between,
send, all right.
I'm trying to decide one or two. Now, by the way, because you don't really have credit, right? I mean, there's a couple days.
Couple of days, right?
Yeah, 16 days. That means if I give you a prison term, I guarantee within the first 2 months, I'm gonna get, when I say I guarantee, that means if you apply to the program. If you don't do it, then I'm not gonna get a letter. But if I get a letter, I'm gonna say, heck yeah, put them in the program. The program's 90 days, which by the way, is more than you would get for good conduct time. I take that off of the sentence in my mind. Then I take off more as an incentive for you doing the program. So if you get put in the program, you could be out in 6 months. Realistically, what I'm saying, I'm trying to come up with a creative way to help you, Mr. Eargood. In other words, because you haven't had a lot of that supervision, maybe I become the big bad mean daddy or uncle or idiot from down the street or neighbor. I don't know, whatever. Maybe it's kind of like the guy from the movie Gran Torino. I don't know. I like to think of myself as Clint Eastwood. Go ahead, sir.
If I may, Your Honor, weigh in. In a local sentence, if the court approved it, he could continue working to pay his fines and costs on work release, have the treatment inside the jail from,
And hold on, what is the status of our work release right now?
it is in place.
Is it? Because we had,
Yes.
it kind of gone on, it's gone off.
That when I had Mr. Young, I looked into it because the court had authorized it, and it is in place right now.
Where's his job?
Hutchinson's.
That's right, thanks.
So he could work,
I
he
got it.
could get the treatment in the jail
I got it.
and then be placed in an outpatient or inpatient locally if available. My concern is exactly what the court said, which is once he's released after boot camp, will MDOC put him
Well.
into a rehab, things like that?
All right, so that's a good point. And I know I put a lot of weight in work. And hard work especially. All right, here we go. Court sentences the defendant to a 24-month period of probation. The court adopts the terms and conditions listed on CFJ 145 pages 2 and 3, therefore, which I find are appropriate for the sentence and the defendant's history. The court therefore assesses a supervision fee of $30 a month, $60 a month if there's electronic monitoring. The court sentences the defendant to 365 days in the county jail with 16 days of credit. The court will, as long as the defendant and the job qualify, the court does approve work release. Okay.
Okay.
Now, that's because I want you to have that job. Don't lose the job.
No, so I just, clarifying what's,
I'll come and explain.
all right, I just wanted to-
Ask him. I can't give you advice. And
you're fine. I just wanted to make sure.
smart enough. I mean, believe it or not.
I'm sure
Thank you, Your Honor.
No problem.
I understand.
All right. Thank you all very much. Now, hold on. Fail to do. No, I didn't. Mr. Chair is going to bring you two pieces of one piece of paper. You're going to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges receipt of your copy of the document. Now, this document says that you have the right to appeal the conviction and sentence in your case, and that is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to consider appointing an attorney to assist you, so the bottom half, then return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. All fines and costs are due within 56 days, or a 20% penalty will be added. However, I will waive that penalty as long as you are making payments while you're either in jail or while you are in probation. All right, so as long as you're making payments, then that will be waived. Anything further, Ms. Odell,
No, Your Honor, thank you.
Mr. Ringstrom,
No, Your Honor.
Mr. Cherry?
Two follow-up questions, Your Honor. One, you talked briefly about sending them to treatment in lieu of incarceration at some point.
Ms. Odell knows, and shouldn't, they all know. If they can get somebody into an inpatient program, I'll do it.
And number two, is he eligible for early release from probation?
Oh, sorry, thank you. That's what I have to say. With the right to be considered for early release from the probation at halftime if you are successful with completing all the terms and conditions, which includes paying all your fines and costs. Thank you.
Thank you, Your Honor.
We're adjourned.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.